frequently asked question number 1 is, so if my spouse, if I'm doing an adjustment of status to marriage case, which means my spouse is the one petitioning for me, do we have to be living together? At some point, definitely yes. Now, I've done cases where we filed the case, and maybe because one person or one partner was in school in a different city or something like that, maybe they weren't living together. But eventually, I always tell them, okay, I will tell them, make sure you're just living together. By the time they call us for the interview, or by the time they're about to call us for the interview, you need to be living together. So obviously, you would need to determine when, how long typically these applications normally take. And then just plan to make sure you're living together at that time. And then I always say, even after the interview, you want to be living together, because sometimes immigration may want to come and do a drop by and see, check things out. So you definitely want to be living together. Frequently asked question number 2, my spouse petitioned for me and then died. Okay, so my spouse died before the I-130 or before the process was approved. What can I do? So there's 2 things you can do in that situation. So if you have a pending application, typically one of the things you could do first of all is you could see if you could find a substitute petitioner. And that's just usually someone who's a U.S. citizen or a green card holder as well, who would not mind, in other words, kind of taking the place of your spouse in this application. So you could find a substitute petitioner. Second thing is you may actually have the option of filing for VAWA. One of the benefits of VAWA is you could actually file, in other words, file an I-360 form, which is a self-petitioner form on the basis of your spouse having passed away. And especially if your spouse was abusive or you had issues in the marriage and your spouse died, great. You could definitely then, in that case, file a VAWA application or an I-360 form on the basis of your spouse now having deceased, okay? And the third thing is, actually, if you have a good lawyer, your lawyer could just write them and explain the situation and point out the laws and policies. There's some laws and policies that USCIS has recently passed that would say that in that situation, they may actually allow you to continue your application even after your spouse is dead and even before your application was approved. So there's 3 different things you could do. Give me a call if you're in this situation. If your spouse has recently deceased and you're not sure what to do, then you definitely want to give me a call. Let's talk about your options. You have usually at least 2 options that I've discussed now.